very much indeed, Chairman. Prime Minister, when and how did you, in number 10, make substantial and unexpected changes in the White Paper proposals in the run-up to Chequers? And did you and or Ollie Robbins show the proposals to Angela Merkel and or the EU before showing them to the Cabinet? If so, this prima facie would be, I would suggest, contrary to the ministerial and the civil service codes. Did you ask the law officers for their opinion on the white paper as required by the ministerial code before the Chequers meeting? And if so, was this consultation with them, and I use the words in the ministerial code, in good time, given its critical legal and constitutional importance, and if so, when?
Well, first of all, can I lay on the head? I mean, there has been a suggestion I've seen that we actually took copies of the white paper and showed it to people outside of the United Kingdom. We did not. You ask about the ideas that are in the white paper. In fact, ideas that are in the white paper, some of the ideas that are in the white paper that perhaps have caused most debate and discussion following the Chequers agreement and the publication of the white paper were ideas that were set out as potential issues for us to look at in the Florence speech that I gave last September. There had been discussions about these throughout, and that was slightly fleshed out in the Mansion House speech that I gave earlier this year. So those proposals were there and were considered and looked at by ministers. We then decided the route that we were going to take, and we spent some time discussing that with the European Commission, and obviously in terms of the negotiations with the European Union. It became clear that that was not negotiable. Alongside that, of course, we were looking at the customs arrangements in relation to the two options that had originally been on the table, and then refining those two options to ensure that we could deliver on the frictionless trade at the border and the no border with Northern Ireland. What became clear was that it was necessary to evolve the Mansion House position, and in advance of that Cabinet meeting there was discussion about that particular issue. As I say, the underlying concept was one that had been previously discussed because it was there actually in the not Lancaster House, Florence, and then in the Mansion House speeches.
And the law officers? Did you ask them for their opinion in good time as required by the ministerial code, and what was their response?
Well, as I know, Sir William, you will know, we don't normally give in public details of law officers' opinions that are given to the government. But I can assure you that all those who needed to be involved in this and who needed to be to look at this from their responsibilities were involved.
And that did include the law officers, as a matter of fact.
As a matter of fact, the law officer sits around the cabinet table and is somebody who is consulted through that process.
Thank you. Now, the Common Rule Book is an EU rule book. The former president of the EFTA Court has just very recently, the last few days, stated that under it, and I quote, the UK would recognise that the ECJ is supreme on the interpretation of EU law, close quote, and under the independent arbitration system, we would agree to refer questions to the ECJ. The ECJ will determine not only the interpretation, but also the outcome of any disputes. Now, under the similar Ukraine, Georgia and Moldova treaties, the ECJ in practice decides, not the arbitrators. So given what the former president of the EFTA Court has so recently stated, and I think it's generally understood that he understands this stuff very well, how on earth could you argue that the white paper does discontinue ECJ jurisdiction, and how do you reconcile, as I asked you in the House the other day, the repeal of the 1972 Act with the continuing application of the functions of the European Court of Justice to the UK, when, as you know only too well, Section 3 of the European Community Act 1972 is the jurisdiction of the European Court over the UK and domestic law, and under the Repeal Act, that is actually going to be repealed on exit day.
We acknowledge in the White Paper the role that the European Court of Justice has in being the determinant of the interpretation of European Union law. And that is acknowledged in the White Paper. But we will not be under the jurisdiction of the European Court of Justice. Through the proposals that are in here, as we say, in those cases where there is a dispute which involves the interpretation of EU law, and in the industrial goods acquis, of course, there is a significant volume, a significant amount of case law already in existence in relation to the interpretation of those rules, many of which have been stable, have not changed for some time. Then it will be possible through those processes to ask for an opinion from the European Court of Justice on the interpretation of EU law. The European Court of Justice would not determine any dispute that takes place, that is in question at the time. The court of one party cannot be the arbiter in terms of a dispute between two parties. It would be, obviously we've got if you like, the hierarchy of determinations of disputes that takes place. The European Court of Justice, by definition, as the arbiter of EU law, would have an influence, but it would have an influence in cases even when we had no deal with the European Union. Because if you were a business that was exporting to the European Union and doing so on the basis of EU rules, and there was a dispute, your importer, for example, raised a dispute about whether you had met those EU rules, the arbiter of that EU rule would be the European Court of Justice. In terms of disputes that are taken before the courts in the UK, they will go to the UK courts, they will be determined by the UK courts.
I understand that is the direction, the trajectory of your answer, but I still leave on the table the questions I've asked, and I remain unconvinced at the moment, but we shall continue this, no doubt, in due course.
I suspect, Sir William, you and I may have some further lengthy discussions on some of these legal issues.
Now,
thank you. I think we're going to have to move on to the next section. Thank you very much. So the next chair is Bernard Jenkin. Sir Bernard Jenkin, the chair of the Public Administration and Constitutional Affairs Committee.
Thank you very much, and good afternoon, Prime Minister.
Afternoon.
The White Paper talks about stepping up plans for no deal, and so far there appears to have been some reticence about making announcements about what is being prepared for in the event of no deal. So what's the basis for deciding when to announce what is being done in preparation for no deal?
Well, I think, there are two approaches two aspects that we've looked at. The first is obviously the work that needs to be done by the government in determining the preparations, and then the second is the point at which it is important to be able to ensure that others outside government who would need to be involved are able to have the information that they need. I was going to look. We're not yet on the debate later this afternoon, but the Secretary of State for exiting the EU will be setting out today that over August and September we're going to be releasing a number of technical notifications to set out what UK citizens and businesses need to do in a no-deal scenario. So making much more public awareness of the preparations. We imagine there are going to be around 70 of those technical notices that will be issued. So that's, if you like, taking a next step. The Cabinet did agree that we needed to step up our no-deal preparations, but this is part of those no-deal preparations, is making those technical notices available to those who obviously need to know that information.
Thank you. So if you've ruled out the option of negotiating an FTA with the European Union because they won't negotiate with us on the basis of without the backstop. They won't countenance an FTA without the backstop. That's correct, isn't it?
Well, yes, if I may but this is where language is important. If we talk about a free trade agreement, then the European Union has a single concept of what a free trade agreement is. Mm-hmm. So it's like Canada, that's a free trade agreement. What we're talking about in here is a much wider and more ambitious overall partnership with them. Mm-hmm. So obviously at its heart is a free trade area with the EU. But that's why we don't use the term free trade agreement. But you're right, the two options that were on the table from the EU were on the one hand EEA plus, free movement, customs union, and which I think would not
I
reflect the
think
vote.
short-circuit.
And on the other was a free trade agreement that actually was less good than the Canadian free trade agreement, but with effectively the border down the Irish Sea.
One of the reasons you've given for not going for a Canada plus free trade agreement is that they won't negotiate with us on the basis of Northern Ireland remaining in the same customs area as the rest of the United Kingdom. They won't do that, will they?
Their proposal was for a free trade agreement which actually split Northern Ireland off from Great Britain.
So if we have a WTO Brexit, with or without an agreement, a withdrawal agreement, can you give us an assurance that it will be on the basis of a WTO Brexit that is for the whole of the United Kingdom, and there is no question of splitting Ireland from the rest of the United Kingdom under those circumstances?
Well, I have been, I have said on many, many occasions that one of the targets, one of the aims that I have in relation to the negotiations that we have is to ensure that we retain the United Kingdom together. I believe that is important. I believe our union is very precious. So I will certainly be working to ensure that we are able to maintain, keep the United Kingdom together. As I said in response to the earlier questions,
that's fine.
In a no-deal scenario, of course, we will have to consider what action we take. Others will have to consider what action they take.
The no-deal planning, or the WTO Brexit planning, is planning for an invisible frontier in Northern Ireland.
The planning that is taking place at the moment, the issue of what happens in relation to that is an element that we have to be looking at as we're undertaking the no-deal planning. Yes. The preparatory work that is being undertaken across a whole range of departments and a whole range of ways.
Simple, Prime Minister.
But we have, I'm being careful in answering. Because I've already answered a question like this, and I don't want there to be any misunderstanding between the answers that I'm giving to the same question.
But is the government planning for a no-frontier, invisible customs frontier in Northern Ireland? Because you have to. That's part of the no-deal planning.
As we look at the no-deal planning, one of the elements, one of the issues that we have to look at is one of the elements that we are looking at as part of our no-deal planning is that whole question of the border in Northern Ireland.
Okay, I don't think we're going to get any further on that one. And for matters such as the regulation of chemicals, aviation safety, food safety, and indeed medicines, which the House of Commons voted on yesterday, presumably no-deal planning includes draft legislation in order to provide for regulation of those products in our own market. And when are we going to see that legislation?
No-deal planning does involve looking at the any legislative requirements that are needed for these points. There is, I don't have a timetable for those required legislation at the moment. We have already put through some legislation that is relevant in a no-deal scenario in terms of our preparations for leaving the EU. But there is work that is undertaken, for example, in the relation to EASA, in terms of ensuring you would be looking, for example, there at probably a set of bilateral agreements. And the Department of Transport is looking at that.
But I mean, we will have to probably use the provisions under the EU Withdrawal Act. And we'll have to have regulations under that Act in order to replace those functions. And let's hope that they give us those bilateral agreements, because it would be very destructive and vindictive if they did not. But when do you think we will see those draft regulations or draft acts of Parliament, draft bills?
Well, there are some of the look. There's going to be a whole range of there'll be a whole range of primary and secondary legislation that will be being brought forward over time, obviously. There are a number of, as I said, we've already passed, obviously, the Withdrawal Act, the Nuclear Safeguards Bill, the Sanctions Bill. We're expecting to lay approximately 40 EU exit SIs before recess. This is the work is ongoing. There is a significant number of SIs that need to be laid in all of these areas.
Thank you very much, Prime Minister.